Ladies and gentlemen, welcome back to another fabulous episode of the Healthcare Trailblazers podcast. Today, I am very happy to be sitting here with a very prominent lawyer out from Washington, D.C., Jonathan Tycko. Jonathan has built a gigantic practice. It's you and a partner, I believe, right?
Well, there was two of us that started it. We have about 25 lawyers now. So the firm has grown a lot over the 20 years we've been out here doing it.
That's fantastic. So Jonathan is doing something really, obviously lawyering all over the place, but in healthcare specifically, it's interesting because Jonathan has represented whistleblowers and specifically going after kind of false claims and companies that are fraudulently billing and involved in fraud. A couple years ago, landed a gigantic $350 million settlement against publicly traded companies. So doing a lot of really interesting things. Jonathan, thank you so much for sitting down with us today.
Happy to join you, and thanks for having me on.
Absolutely. So I was telling Jonathan a little bit before we started that I have a personal interest in this conversation because as many of you may know, our company, Proviva Health Group, we provide white labeled services for chronic care management, remote patient monitoring, and helping some of these more difficult to implement Medicare funded programs into doctors' offices across the country. And it's a space that unfortunately some people look at as just an opportunity to check some boxes and collect checks. And obviously that's something that we go with our clients and we say, if there's any kind of gray area and if your mindset is not patient at the front and center, then just don't even start. And I think actually a really hot topic right now is like remote patient monitoring. I think it's a very good example of this because a lot of people are just trying to, like, there's all these companies popping up, remote patient monitoring, like it's the hottest thing since sliced bread. And what I love to remind doctors is that if this is going to be billable, the patient has to take 16 days of readings or one of those specific codes to be billable, which means that if you're just going to be throwing devices out there, it needs to be meaningful to the patient, which is what obviously the intention of the program is, that it's actually helping the patient better their health. And if you're just going to throw devices out there and you're trying to just check boxes so that you can collect the reimbursement, you're going to fail. And literally the line that I use with so many of these clients, I say, when Medicare comes knocking at your door, or in this case, it's going to be Jonathan Tycko comes knocking at your door and says, we gave you $1 million. Why did we do that? You need to have a very, very good answer. And so if you don't feel like this is actually going to be beneficial for this specific patient at this specific time, then probably stay away. So I think that there's a lot of interest specifically in this conversation. But before we get into all that, how did you get started? Where did you grow up, and why law?
Well, I did not come out of the womb wanting to be a lawyer. That interest developed much later. I was born and raised in New York. I grew up on Long Island, and I came from a family that was primarily scientists. Both my parents, and I have two older brothers, all PhD scientists who did primarily, just basic scientific research. And so I just sort of grew up thinking that's what everybody did. And when I started college, I actually started out as a physics major. But somewhere along the way, and I loved science and I loved math and I was good at all of that stuff. But somewhere along the way, I decided that I did not want to pursue it as a career. I wanted to do something different. And so I had to switch majors. And I think history was the only major I could still finish all the requirements in time for. So I switched to history. I had to quickly learn how to write, which you don't really have to do much of it in science and math. And then after I graduated college with a history degree, I started looking around and thinking, well, what could I do with that? And I had a summer internship working at a public defender's office in the city where I went to college. And so I had some exposure to law. And law is sort of applied history in a certain sense. And so I thought, well, maybe that'll just be interesting. I really didn't know that much about legal practice or the business of law or really what I wanted to do with it. It was just sort of law school was like something to do. It was more school. I was good at school. And it seemed sort of interesting. And so I applied and got in. And I went to Columbia Law School, went back to New York for law school, and discovered that I really loved it. And that was many, many years ago now. And I've been practicing now for about 30 years. And, that's kind of the history of my entry into the law world, boiled down significantly.
Very cool. And you grew up in New York?
Yeah, in Stony Brook, Long Island, where my dad was a professor at the SUNY University campus there.
Okay, cool. So you said that you kind of transitioned from history over to law, and you saw like certain similarities. You said that law is almost like an applied version of history or something like that. What are the similarities? How do those two tie into each other?
Well, the United States has what's called a common law system of law, which we inherited from England. And one of the sort of features of common law systems is that they are built primarily on judicial precedent. So the law develops through judicial decisions over time. And the judges that are sitting today are sort of bound by the decisions of their predecessors. And so a lot of sort of figuring out the answers to tricky legal questions has to do with going back and kind of reading these texts, these sort of older texts that were written by judges over time, and trying to sort of, interpret them consistently to come up with an answer to whatever the legal rule is. Now, we also have layered on top of that regulations and statutes, but even those then get interpreted by judges, and the judges' interpretations sort of become the actual law of the land.
Right.
And so in that sense, what lawyers do is sort of like applied history, in the sense that we are going back, we have to do the research to find these decisions that were issued by courts in the past, find the right ones that are kind of relevant to the issues in front of us, and then you read and interpret them. And then often that then leads to you then trying to write something that interprets those prior texts. Either a brief, if you're one of the litigants, or if you're the sitting judge, you then have to write the next opinion kind of in the sequence, right? And so it's that sort of development of the law in the common law system is very history-based, and the skill set there that gets applied by lawyers and judges, I think, is very similar to what historians do.
So is there like a lot of memorization involved? Do you have to store a bunch of this in your head, or is it more just knowing where to look and where to find things?
Well, some of it you just learn and you store in your head, and there are lots of answers to questions that are very straightforward. Right. But it's where you get into kind of the interesting kind of gray area questions or new areas of law that you really have to kind of go through this process of research and analysis. Obviously we have tools for doing that. There are online databases. There's all sorts of tricks for doing the research that you learn along the way. So there is a method to the madness. But basically it's a research and writing, profession. That's what it's about. It's about research, reading, and then writing. That's the what we spend most of our time doing. And so again, it sort of flows naturally from a history degree, I guess.
So how do you go from, you graduate from law school, and now you have this very successful, flourishing practice with 25 partners, and I'm sure bunches of other roles and people and lawyers, people that look at things. What are they called?
Well, we have paralegals and other staff, investigators. There's different people that help us that are not lawyers. Yeah.
So what's the journey to building such a successful law firm?
Well, like a lot of sort of new lawyers coming out of law school, my first sort of private practice job was as an associate at a big firm. So you kind of start out, particularly if you're going to do litigation, which is what I do. You often try to start out working at a big firm where you're working on cases for that firm's clients, and you kind of learn the skills, and you get sort of practice from doing that, and you're being supervised by more senior lawyers. And so I had gone to a big firm in Washington, D.C., and I worked there for about 6.5 years. And during that time, I met and became friends with the guy who was the other named partner in my firm. And somewhere along the way, he and I started just talking about, like, gee, wouldn't it be more fun if we had our own firm? And at some point we sort of outgrew just sort of being an associate at the big firm. And also we wanted to do a different kind of law. I mean, the large law firms in the U.S. are primarily representing large corporations who can afford their very, very high billable rates. And we kind of saw ourselves more as little guy lawyers. We wanted to be on the other side of the cases we were litigating. We didn't always want to be defending the big company. We saw our path as more representing individuals, and hopefully kind of playing a more useful role in society, I suppose. And so it was a combination of wanting to do that different kind of work, but also just having a little bit of kind of entrepreneurial spirit and thinking it might be fun to try to start a business, which neither of us had ever done and didn't know anything about. And so we started out just the two of us. We had the two of us and two laptops, and we sublet a little bit of space from in the back of another law firm who let us have an office. And we started out as just two people, no help. And then just gradually, like I said, we've been in business about 20 years, and just slowly get busier. And then when you get busier, you kind of hire the next person to help you and the next person to help you. And then those people kind of move up the ranks, and then they start to generate business. And as long as you can kind of keep the group together, it sort of has a natural tendency to grow. I mean, a law firm, I'm sure this is very similar to a physician practice. A law firm is just a group of individuals, and it sticks together only for as long as the individuals find some benefit to sticking together.
Right.
And so law firms come and go, they break apart, they splinter apart, people go their separate ways. We've managed to hold it together for 20 years, which is pretty good.
Nice. That's a great track record. So
yeah,
you're actually not the real life Harvey Specter. You're the real life Mike Ross.
I have no idea what that means, but okay.
I have no idea what that means, because doctors hate watching medical shows, and lawyers, I'm sure, hate watching lawyer shows. But I'm sure you've never touched Suits or anything like that. But do you? There's like societal conceptions or misconceptions about how hotshot lawyers operate based on these shows. Are there any? Is there any common kind of misconception that you find yourself hearing, and is there anything that people get right about the spectacular lawyers?
Yeah, I mean, well, when I was in law school, we watched L.A. Law, which was the original kind of like TV show that glamorized being a lawyer.
Okay,
and that show was popular in the early '90s when I went to law school. So, I mean, Suits, I guess, is the current version of that. And there's been lots of lawyer shows over the years. Misperceptions. Well, I think the TV shows tend to give people two impressions about litigation that turn out to not be true. One, the first is that, in a TV show, every case has to start and then get resolved in 1 hour, right? In reality, these cases go on for years. If we can start, the kind of case we're going to eventually be talking about today, these False Claims Act cases, if we can start one of those and get to the end within 3 years, that's really good. So litigation is slow. That's the first thing. The second thing is that on TV shows, lots of cases go to trial and in front of juries. In our actual civil litigation system, almost no cases ever go to a jury trial. The whole system is designed to avoid jury trials, not to encourage them. And so jury trials are few and far between in civil litigation, and most cases are resolved either through what we call motions practice, where the case is basically just decided by a judge without a jury, or they settle. And that's really what the civil litigation system is really designed to try to achieve settlements. It's not designed to lead to jury trials. And so jury trials are dramatic and they make for good TV, but in the real world of civil litigation, they don't happen very frequently.
Huh. So you're not doing mock trials at the law firm with everybody wearing hats and being juries and judges and that. That's all.
No, I mean, we maybe once a year we have a trial or something like that, and that's out of a book of 100 cases. So it's that it does happen once in a while, but it's not a daily occurrence.
Yeah. So speaking of settlements, let's talk about one of the gigantic cases that you worked on. I know the end result was a $350 million settlement from a publicly traded company. Talk to us a little bit about that case.
Yeah, so this was what you're talking about is the advanced biohealing case, which settled a few years back, and this is sort of a good example of kind of what we do now that's healthcare related. So this case started out as a small sort of biotech startup called Advanced Biohealing that had developed an artificial, what they called an artificial skin that was used for wound healing. Um, a common use of this was for, advanced stage diabetics who will develop sort of open sores on their feet. And this is a product that was at least marketed as something that could help heal those. And the company, when it first started, decided as a marketing strategy that they were going to try to penetrate the VA system, where there's a large population of people that have this problem. And they also saw the VA system as sort of susceptible to the types of marketing tactics that they wanted to try. And what they did is they gave their sales reps kind of a blank check and a budget and said, go sell this stuff to VA hospitals. And what the sales reps would do, they would put on scrubs so that they would blend in. They would show up at the hospital. They would sort of try to figure out within each facility sort of who were kind of the influencers. I guess that's a word we would use now, right? Who within that facility are the doctors who the other doctors look up to, who controls the purchasing decisions, who's really kind of deciding which product to use to treat patients. And then they would start to try to figure out, well, what is that person like? How can we be friends with this person? And they would start out with maybe meals, and then it would elevate to like tickets to a concert, maybe a trip somewhere nice for them and their wife, all the way up to some of the sales reps were buying for the doctors rare coins, antique guns. Sometimes there were just literally envelopes of cash changing hands. And in any of these big kickback cases, there are often, let's just say more seedy things that they use to try to influence purchasing decisions. And this was extremely successful. The VA adoption of this product within 2 years just skyrocketed. Hundreds of millions of dollars a year that the VA was spending on this product. Now, I should also say that product was very expensive. It was over $1,000 per application. And the evidence that it was really any better than anything else that the doctors could have used was pretty weak.
Okay, so question. What's the difference between a bribe and a kickback, and when does one bleed over into the other? Because if they're greasing the wheels so that you make that decision, then the decision's made, and then the product may stand or crash on its own merit, versus obviously if you're consistently, what's the difference between bribery and kickback?
Right. So technically what we're talking about here is a federal statute called the anti-kickback statute. And as it applies in the healthcare world, it's really any sort of financial incentive, any inducement to use a product or perform a procedure, if that product or procedure is ultimately going to be billed to a government healthcare program, Medicare or Medicaid. So it doesn't have to be envelopes of cash. It could be something as simple as, a nice dinner. And I will say that the large established pharmaceutical companies have pretty good compliance programs. They understand the statute, and their salespeople have to get trained on this, what they can and can't do. Although there is this sort of like whack-a-mole to the anti-kickback statute, in the sense that even the large pharmaceutical companies that are very sophisticated in this area still get in trouble under the statute, because they do know, and this has been sort of proven through studies, that even very highly trained, sophisticated doctors are, almost subconsciously susceptible to influence through relatively small inducements. It's just that little bit of time where I'm going to give you a little bit of something you might like, or make your life a little easier in some way. And even though the doctors themselves, if you sit down with them, will always say, oh, no, 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 of course, when it came time to write the prescription, that was nowhere in my head.
Right. Right.
When anytime anybody ever studies this systematically, they find that actually, statistically, these even very small incentives end up influencing prescribing decisions quite significantly. And the pharmaceutical companies know that, and that's why they kind of spread this goodwill. And they try to do it in different ways. Currently the big issue is, what the pharmaceutical companies call speaker programs, or, other things where they're sort of engaging with doctors in ways that might have sort of these side benefits for the doctors. It helps the doctors network,
Right.
or it gets the doctor invited somewhere to a meeting, or it helps the doctor publish something with their name on it. And and there are ways in which even that kind of activity could cross into being a violation of the anti-kickback statute. What advanced biohealing was doing was not even close. They were absolutely violating the statute, no question about it. It was very successful. They were so successful that the company was then able to sell itself to Shire, a big pharmaceutical company. Shire bought Advanced Biohealing, I think, for $750 million. And the original investors and owners of that company walked away with a lot of money.
Right.
Fairly soon after Shire bought the company, they get a subpoena from the Department of Justice, which was the result of whistleblowers coming forward, like my client and some others who worked in the company. And when Shire got the subpoena, they internally start to look into what this company that they've now bought is doing. Fairly soon after that, they issue a directive to the Advanced Biohealing salespeople. We're taking away the sort of like budget that you had. You have to now follow the rules. And pretty much as soon as they did that, the sales of this product at the VA went off a cliff.
Wow.
Because as soon as they were no longer able to provide the kickbacks to the doctors and the other people at the VA system, there wasn't really any reason to use this product. Shire ended up writing off their entire investment in ABH. I don't even think this product's on the market anymore. And they ended up paying $350 million to settle with the Department of Justice.
Shire or ABH?
Well, Shire, because they were the owners of ABH at that point in time. Some of the individuals who had been the ABH executives who kind of ran this marketing program actually had criminal cases brought against them.
Wow.
And there were a number of plea deals, because if you do this with enough intentionality, the government will come after you criminally.
Yeah. So kind of a sidebar, but I find this interesting in general. So, Mike, I think right now you're seeing this kind of play out with Tesla, right? Where Elon Musk said, I think Tesla's doing not Tesla, Twitter, right? Where Elon Musk is saying, I think Twitter's doing XYZ wrong. So he goes ahead and buys Twitter, but he's then busy saying, these are all the things that the previous company did wrong. And he's actually like cooperating, or it seems to be cooperating and bringing things out and showing evidence that the previous company was doing, things that were nefarious or wrong or contrary to the interest of the shareholder, whatever it is, right? But doesn't that but he is now the owner of Twitter. So isn't he, so like, how does, so if you can go after the new company and there's no way to go after the old company, then doesn't that kind of incentivize the new company to not cooperate with you guys? Like, is there any way to go after the old people, or they walk away and they're done?
Well, like I said, in our case, the government did go after the people that were actually directly involved in the original company that were kind of responsible for the kickbacks. So if you plan and execute a fraud scheme, you are personally going to be liable, both civilly and potentially criminally if it's bad enough. And the fact that you sell the company is not going to insulate you personally. But now when you're talking about this, they had sold hundreds of millions of dollars of this product by the time DOJ shows up. And so what what DOJ is trying to do civilly is recover that money for the Medicare program. And often the original owners that were, owned the startup company, they don't have $350 million. They walked away with plenty of money, but, a lot of that money just is gone by the time you come on the scene. So the bigger company that has now absorbed that startup becomes the target of the civil case,
Right.
which is mostly just about money.
Right. Interesting. So yeah, really. And then obviously the $350 million, like you said, goes back to who it was taken from, which is Medicare, Medicaid.
Correct. Yes. Yes. And the whistleblowers get a share of it as kind of their incentive, their reward for coming forward. But most of it just goes back to the government, right?
Got it. So let's talk about the kickback statute in general, because going back to kind of some of the things you were saying, where it can kind of like, there's got to be some hard lines, I would imagine, because once some of the things we're mentioning where it kind of gets into the nitty gritty. If I'm taking you out to dinner, that's, you know what I mean, that can maybe potentially that's a kickback or some sort of bribery or some sort of scheme. But I mean, I'm curious where the line is, because I would argue that, especially given today's ability to market to people, you can probably be, when you talk about an influencing, right? At the end of the day, sales is influence, right? Whether just me being charming or me, right? And then today, my point is that sitting down to dinner with somebody is just a platform to facilitate a conversation. Obviously, again, I'm kind of playing devil's advocate here. You always need a platform to talk to your target, right? And where I was going with earlier is I would always argue that given today's ability to market and target people so directly to what you were saying earlier, to their interests and to their passions and kind of target them so directly, there's areas to really just, even if there's no apparent money exchanging hands, but if you talk from an influence perspective, I can influence somebody dramatically in their decision making without even getting in a room with them. So where's that line between that, sitting down to dinner, then obviously at the other end of the extreme, here's $100,000, right?
Well, there's nothing wrong with trying to influence purchasing decisions. That's what marketing is, and pharmaceutical companies and device manufacturers have an absolute right to do that. They can go to a provider and say, you should use our drug because our drug is good. There's nothing wrong with that, and that's what they should be doing, right? We want them to be doing that. We want them to be developing new products, and we want there to be some competition there, and we want the doctors and the other providers to be informed of what's out there and what they can use. And so there's absolutely nothing illegal or wrong with trying to just sort of sell your product, market your product, and explain what it does and why it's better than the competition. That's totally acceptable and fine. What you're not allowed to do is to try to, create a financial incentive for the use of your product. And yes, okay, so and the gray areas, I think, really are mostly in this kind of like, well, okay, I take the doctor out to dinner, I pay for her hamburger, and then over the dinner, I have a conversation with her about our new product and why she should prescribe that to her patients. If it's a one-time thing and that's all that happens, it's not going to be a problem. It becomes a problem where you are, really. Here's where I would say, if I take you to dinner, and the purpose of taking you to dinner is to introduce you to my product and make a pitch for why it's good, and then at the end of the dinner we shake hands, and I go my way, you go your way, and then you can decide whether to use that product in the future or not. Totally fine, no problem. Here's where it becomes a problem. I take you to dinner, and at the end of the dinner, I say to you, I'd really love to have dinner with you again. And what kind of food do you like? What is there a restaurant in town that you have a hard time getting a reservation in? Oh, well, maybe next time, after you've used our product a few times, why don't I take you to dinner again?
Sorry.
Okay. So now
we're after you use our product a couple
So
times.
now we're slowly crossing the line into, okay, it's not just me trying to explain my product and sell it to you. I'm trying to incentivize you now to use the product, right?
So everything in that sentence was fine until you said after you use my product a couple times.
Right. Exactly. And so if I do this enough times, right, then it starts to become okay. And I might be doing this to other doctors, right? And so now the doctors start to get the message, if I use this company's product, then I get invited to these nice dinners at the fancy restaurant. If I don't, if I use the competitor's product, I don't get invited, right? And that's when you started to cross the line. That's when you started to cross the line, I think, into using the dinner itself, not just to convey information, but as a sort of a form of kickback. I'm now incentivizing you to use the product with something other than just the merits of the product itself.
Yeah, it's definitely interesting. I mean, again, I could, on the flip side, I would say that it would be obvious, even if I didn't say that part of the sentence, and I just said, you know, this is my product. It was great hanging out with you. Would love to catch up in a couple weeks. You know, after things settle down, blah blah blah. Let's go out again. I don't mention the part of, but I'm a great guy, and you just had a great experience. I took you to a 5-star restaurant, had a great time. And the obvious understanding is that if we're not doing business together, then I have no reason to court you, kind of thing, right?
Yeah.
Yeah.
And what I would add is that if I was trying to sell you computers or, paper to use in your copier machine, this would totally be fine. This is sort of normal practice in most businesses. The kind of, you scratch my back, I'll scratch your thing. You use my company at the end of the year, I'll send you a nice case of champagne or whatever.
Right.
People do it in the law world. Right. It's totally normal and totally legal in every business except healthcare. And that's because the anti-kickback statute is intended to try to protect healthcare decisions from this kind of influence, because those healthcare decisions are affecting patients. And so it's really, all of this is sort of intended to try to protect, this medical decision-making on behalf of patients.
Right.
And to try to take financial influence out of that as much as possible.
Right. Okay, so, and I would imagine another important caveat is to mention the personal financial gain. So, for example, I'm going to a conference in 2 weeks, right? And I plan on putting on a little party and inviting, leads that I think would benefit from the program that we run. Their healthcare organization is a good fit. They've got a good demographic for it. But I want to get in a room with them to be able to present to them properly. I'm obviously not going to be tapping them on the shoulder in the middle of someone else's presentation. So I'm going to pay for that party. They're going to be arriving to that party, and I'm going to use that party as a platform to pitch this, which will then down the road end up being reimbursed by Medicare. Does that open me up to liability, or are we saying, well, there's no individual financial gain? I'm paying for it, but it's not incentivizing you.
Yeah, no, I don't think there's anything wrong with that. Again, it's like I'm making a bunch of assumptions about how you're going to do it. People aren't going to walk out with a basket full of gold coins.
Right.
They're not. You're not going to set up a system where you're dangling other incentives down the road for the people who use your services, but not for people who don't. I mean, again, I think the devil's in the detail. And I will say most of these cases, the big kickbacks cases, at the end of the day, they're made statistically often. Because as you point out, the chances that there's going to be like a written document where people like are being explicit about the bribe are low.
Yeah.
And so what the government often looks at is like, what was the company doing? And then how were the providers actually responding? Was there, and can they sort of build that connection between the marketing program and the sort of overuse of the product or service that the company is marketing? Like I said, in the example that I was talking about, the ABH case, that connection was extremely clear, because as soon as the incentives ended, the use of the product plummeted. It was clear that the doctors were not using it because they thought it was best for the patient.
So oddly enough, it probably would have helped their case. I mean, correct me if I'm wrong, but it probably would have helped Shire, right? Shire?
that Shire was the company that ultimately paid.
Probably
Yeah.
going to help their case had they not cut off the ability for the salespeople to go writing checks, because that's what kind of proved, take away the bribe and product goes down.
Yeah, I mean, I think again in that case, the kickbacks were so obviously illegal that it was not a gray area case.
Right. And taking away from what you're saying, I think safe to say for all the providers out there, people running organizations, well, this isn't really provider facing. We'll get there in a second, but if you've got a program in place that is designed to incentivize doctors to adopt product, service, etc., and it's very clear and you're being malicious about it, then you'll probably get caught. And if you are not being malicious about it, use some common sense, but you're probably going to be fine. Would that be generally safe to say?
Yes, absolutely. And I will say that, like, the cases that I see, if that was all that was happening, you would think the entire healthcare system is corrupt. But I know that that's not true. What we're seeing is sort of the small percentage of people in the healthcare business that are trying to make money off of it in a corrupt way, and the vast majority of people in the healthcare system are in it for the right reasons. Want to improve the system, want to do well by patients. And in fact, the vast majority of our clients in these healthcare cases are themselves in the healthcare business. They are doctors, nurses, other people working in the healthcare. They're inside this business, and it's often the people who are trying to do things the right way who are the ones who become the whistleblowers. So because the doctor sees all this stuff going on around them that they think is shady and wrong, and is interfering with their ability to just treat patients the way they want to treat them. Right. That's often what kind of starts these cases.
Right. I don't know if this is an area of expertise or not, but I think that if we could talk about something that I think will be very practical to doctors, because the cases that we're kind of talking about are the people that are selling to doctors. Let's move it down a level to doctor-patient relationship, right? And the kickbacks there. So there's really is a struggle for doctors when it comes to, sometimes there is a program that that patients need an incentive to choose to be a part of. And them being a part of that program will better their health, will actually, let's say, save Medicare money, right? Take some of these preventive programs like we're running, chronic care management, remote patient monitoring, things like that. But the patient needs some sort of incentive. And this can be as little as, like, I've seen, there's definitely legal ways to do this. I've seen things as simple as when my kid recently had went for his annual, and there was a $10 Walmart gift card at our door from the doctor, and this is a massive system. I'm sure they have their compliance in check, right? And they're like, good job for doing this, and it's very good for my child to go get their annual. It's good for the practice, it's good for the insurance, it's good for my child, it's good for basically everybody involved, because everybody, my child is proactively being healthy, and insurance is saving money because my child is proactively healthy, etc. So that could be maybe one end of the spectrum. The other end, obviously, which would seem to me to be illegal, I'm not the lawyer in this conversation, but where you're telling your patient, hey, there's this really good program, it's a really high reimbursement for me, come in, let me do it with you, and I'm gonna obviously pay you money. I think that's the obvious other end of the spectrum. But there's something with, like, dealing with copays and getting patients that can't pay with their copay, but they would still benefit from being in the program. Is that level of the kickback statute an area that you're familiar with?
Yeah, well, you covered a lot of different possibilities there. So, and the devil is in the details here. So a program that is directed primarily at kids, for example, may not violate the anti-kickback statute for the simple reason that their health care isn't being paid for by Medicare. Now, they might be Medicaid covered, in which case it would, but if they're all private pay doesn't implicate the anti-kickback statute. The reimbursement or the waiver of copays is an area that some big providers have gotten in trouble. HHS, Health and Human Services, takes the position that if it is a Medicare beneficiary that owes a copay, that waiving the copay or reimbursing the copay or somehow subsidizing the use of the service or the product, that does violate the anti-kickback statute. So again, the devil's kind of in the details.
Yeah,
Your
no,
patient.
this is something we've looked at. I'll give you like a real example. And we chose not to do this because we felt it was getting too close to this area. But there's a small copay for some of these preventive care programs, right? And it's stupid that there is a copay because these are things that Medicare wants the patient to do. And you take things like the annual wellness visit where there is no copay, and it's the same arena of preventive care service. And the idea is if patient is proactively, for example, if we're making sure that, second patient turns 50, they get their colonoscopy, whatever preventive screens and tests, we are statistically saving the insurance money because we're making sure, we're catching things early, where things aren't falling through the cracks, or we're not being reactive, we're being proactive, right? So we were trying to look at, can we create a program where patient will be responsible for this small copay, but we'll create like a reward system for them actually benefiting their own health. So actually being a part of the program and taking action on their health goals. And we kind of create a separate incentive structure for patients to be proactive about their health and follow through on goals that at the end of the day they'll come out in the black kind of thing with their copay. Now, totally separate and not necessarily connected. Again, we didn't go in that direction because I felt it was too close, but I think that's a good maybe example where we're trying to actually do the right thing. It wasn't a financial thing. It was like, these patients need this program. Their big hang up is this $4 copay. How do we, you know what I mean?
Yeah. Yeah. No, I mean, that is tricky. And as you probably know, HHS has different programs out there for physician practice groups where the physician practice groups can try to do things that would otherwise violate the anti-kickback statute if they agree to be paid, in a different way. So I'm thinking about, managed care, capital, they're called accountable care organizations.
Yeah.
Yeah. And so, if it, and maybe you know this better than I do, but my basic understanding is that there are, if the physician practice group is willing to sort of get off the pure, fee for service way of being paid and move towards something that's more like capitated payments, right? Then the idea, at least, is that the underlying concerns of the anti-kickback statute sort of go away. And then the physician practice group can try things like what you're talking about without worrying about the legal consequences of it. But that is a very technical area. There's a whole process you have to go through, I think, to apply to sort of get into one of those programs. And I would say any physician or practice group that is thinking about doing that should make sure they have good legal counsel before they start a program like that, because there definitely are ways to do it, and HHS, I think, is open to experimentation with that, because what you're saying is absolutely right. There are circumstances where things that a physician practice group could do that would otherwise violate the anti-kickback statute, just technically, might actually be a good idea and might be motivated by good motivations, not evil ones. And I think HHS recognizes that, and they've tried through these other programs to create some flexibility for practice groups to do that.
I think that's a fabulous point and a great legal pitch for people joining ACOs. I mean, at the practice level, we've got ACO partners you can reach out to us that are absolutely fabulous, executing for hundreds of practices around the country. Going back to the doctors for a second, this is I think great advice for doctors. First of all, don't wear all the hats. Outsource what you can. And I think that the fact that you brought in ACO as an answer for this is actually super apparent and almost obvious. And the problem is that doctors are sometimes so underwater that they're not able to lift their heads up for a second to breathe, to look around to what's a good option for me. And I think that joining an ACO is actually a great option. And I know with the ACO Reach program that just came out this year, there's actually a lot of this that's baked in where it gives the leeway and the latitude for these ACOs to actually decide to waive copays, because like you said, they're getting capitated payment, they're taking on risk. Now they're able to kind of go about that. So that's a great option. Okay. I want to talk about an issue that I've been coming across lately, and that's a lot of these Medicare Advantage plans. A lot of these Medicare Advantage plans, I think, are getting in trouble for various things, paying, not paying. I know in my personal business, there's a bunch of Medicare Advantage plans that are not reimbursing for the various CPT codes that we bill for. And I was talking to one of the chief executive officers at, well, not the CEO, but one of the executive people at Medicare. And I was saying, what's the deal with these Medicare Advantage plans not paying? And he said, they're not paying? It's like they're supposed to pay. And I'm like, well, who do I tell on? So now I'm sitting with you and I'm like, I want to be a whistleblower. Hey,
Yeah.
So, have you had any experience with MA plans and their practices?
Yes. And there have been False Claims Act cases brought against managed care organizations. So, the way I and it took me a while to kind of understand how they work and how they could be violating the False Claims Act, because your initial thought is, well, if they're just getting paid on a capitated basis, what difference does it make to the government what they're doing? But it turns out that it does, because it's never that simple, right? And so here's kind of how I think about it. There's sort of two sets of codes that you know about, right? There's billing codes, the CPT codes, and then there's diagnosis codes. So traditionally, large physician practice groups or hospitals would get into trouble for playing around with the CPT codes, with the billing codes. They would upcode, they would unbundle, they would do different things where, the service that provided was one thing, but then they would use a billing code that got them paid, an extra $10, and over time that starts to add up. And so in the early days of the False Claims Act, there were lots of billing code cases. And there still are, because people still just do that kind of sort of very simple fraud, just upcoding.
Right.
With managed care, that kind of CPT code fraud no longer seems to matter to the government, because why should the government care what CPT codes the doctors are using? The government sort of pays the same no matter what, because the government is paying the managed care organization, not paying the doctors, right? The doctors, like in your scenario, might have a fight with the managed care organization about that. You might say, I'm billing for things and not getting paid. I mean, I guess I would say, at the end of the day, you must at least just have a breach of contract claim.
So sorry, these are not accountable care organizations. These are Medicare Advantage plans. Am I understanding the Medicare Advantage plan, unless maybe I have a misconception?
Yeah,
my understanding is that it's a private version of Medicare. So they're basically Medicare saying, I don't want to be a B2C company. I'd rather be a B2B company. So I'm going to give you the money, but then you handle the payment. But they're still pay these CPT codes.
Right. No. I totally get it. So you're dealing with what is essentially a private insurer in that situation. You're no longer billing the government. You're billing this intermediary that's basically acting as a private insurance company that's being paid by the government on a capitated basis to insure your patient population. So, I mean, this is just talking off the cuff. I've never dealt with this issue. Yeah. But my guess is that if you had a group of doctors that was simply not being paid by that intermediary, by that insurance company, that at a minimum, they would have just a breach of contract claim. I did the work, I billed for it, you didn't pay me. I mean, and that's not False Claims Act stuff. That's just, I'm not getting paid, So if you had to sue, I would imagine it would be that type of case. Where the Medicare Advantage plans get into trouble, though, is in under the False Claims Act, is in messing around with diagnosis codes, because the capitated payments are not, there isn't just one level of capitated payment.
Right.
There's multiple levels of capitated payment. And so they have a financial incentive, if they're trying to be nefarious, to make their patient population appear sicker than it really is.
Interesting. And so how do you audit for that? What are you going to start sending doctors to patients' homes and seeing if they actually do have diabetes, and if it's level 1, 2, 3, or you know what I mean?
Well, this is why these cases almost always start with a whistleblower, because it's only the people that are inside the company and see it happening that would ever even know. And so the cases often start with a whistleblower, somebody like our patients who brings one of these key TAM cases under the False Claims Act, and that's how the government finds out about it.
Right. That's I think that the shift to value-based care solves a lot of the root cause of people looking to screw the system, because if you take away the financial incentive for patient being sick, and you move over to the financial incentive now is for patients to stay healthy, then you kind of take away a lot of that. But to your point, maybe you don't, and it just shifts over to, all right, well, I'm getting paid based on me saving money, which means that my benchmark is patients being very sick. So now my incentive is just to move that up. So now say, no, my patients are really sick. And so look how much money I'm saving you, right? Because
I mean, I guess if you're not, and then if at the same time you're not paying the doctors, then
now you're on all sides. So that's
yeah.
really interesting. And I think it just comes back to maybe human nature. Like we'll always find a way to be greedy and try to screw the system. Is there a solution in your mind? Is there something that could be changed fundamentally that would stop a lot of the fraud in healthcare?
Well, like I agree with you that these sort of managed care capitated payment systems are probably, from a fraud prevention perspective, I'm not a healthcare policy person, but from a fraud prevention perspective, I would think on average, those systems are there's less opportunity and incentives for fraud. So in that sense, they are good. There will always be people who will try to find ways to game any complicated regulatory system. And so, but like I said, that those are the outliers. Most people play by the rules, are doing the right thing. You have laws in place precisely because there are outliers. I mean, it's for all of human history, it's been against the law to murder people, and yet people are still murdered, right? So no, I mean, this is it. This is why we have laws. No matter what the rules are, somebody will break the rules, right? And so that's why you have the laws. That's why you have courts. That's why you have people like me doing what we're doing. But from a policy perspective, I do agree with you that I think these sort of experiments in capitated payments and managed care are probably better.
Yeah. And it's definitely the shift. I had the chief medical officer of Medicaid and CHIP on last week, and we've had the chief strategy officer and chief transformation officer of Medicare. So from a policy perspective, I know that's definitely where their mind is at and moving. But from your end, the lawyers aren't going anywhere, and unfortunately, you're not going out of business any day soon. People will always find a way to find loopholes and take advantage.
Yeah, exactly. I'm not worried.
So what are some things that you're working on now in healthcare? If you could talk about it.
Well, yeah. So we've already hit on two of the kind of the big areas, and that's the kickbacks and some of these managed care cases. There are lots of other types of frauds in the healthcare business that we see over and over again. Like I said, there are still very sort of what I think of as like traditional frauds, which are the upcoding, unbundling cases where, and this is just, healthcare providers, doctors, hospitals, just billing they're just using the wrong codes as a way to get more money.
Right.
That's very simple. If they're doing it intentionally, it violates the False Claims Act.
So let's focus on that for a second, because I think that's a good example for the doctors in our audience, right? I know that there are doctors out there that are like, what is going on with healthcare? I'm meant to, I was talking to Dr. Mike about this. He's I think the largest doctor influencer. He's got like 25 million subscribers. Had a great chat with him a couple weeks back, and he was kind of expressing this like, we don't learn about coding in medical school, and then we're sat down, we're expected to code all this stuff. I'm not getting paid for the time that I'm spent documenting coding, and then I got to make sure, like you were saying earlier, it does get pretty tedious. I want to make sure that my diagnosis codes are right, and the ICD-10 codes are correct, and it's the complex code if it is complex, and it's a non-complex code if it's not complex. And you can have a full-time job just worrying about coding, and I think that the concern for some of these doctors is like, I'm obviously not trying to be nefarious. I'm not trying to take advantage of the system. But if I screw up, if I'm miscoding, and it's just because all I'm trying to do is take care of some patients, and I'm sitting here for hours coding and I'm putting in the wrong codes, am I going to get in trouble? And so my question for you is any advice to those people, but more specifically, have you ever seen a case where there's a doctor that was just like blindsided by Jonathan Tycko knocking on his door and being like, you owe us money back? And he's like, what? Has that ever happened?
Well, okay. So remember, our clients are often doctors. And what I've learned from having doctors as clients when they are the whistleblowers is exactly what you're saying, which is that they get no training in medical school about these issues. Like literally none. Or maybe they get like one day where like somebody will come in and talk to them about some business issues.
Right.
But they're totally laser focused on the medicine. Then all of a sudden they get into practice And now there is this whole business side of the business. And my impression is that most doctors are perfectly happy and want to just offload all that stuff to other people. And so that's why you have this whole, profession of billers and coders in the healthcare business. And you have all of these administrative staff and third-party billing companies and all this stuff to kind of take that burden away from the doctors. But I do think that doctors should have some basic awareness and some insight into how their services are being billed. If they totally put that out of their mind and just act like, well, that's not my problem. That's not a doctor issue. That's a something else issue. I'm just going to treat patients and I'm going to pay no attention to how that is being billed, that they are kind of blinding themselves to potential problems. And like most of the time there isn't a problem, as long as everybody that works for them is being honest and, so forth. But when the problems arise, like a lot of our whistleblower clients who are doctors often kind of stumbled on something. They sort of, something was happening in the practice, something about, was going on, and they sort of started to like see things in the billings. They had never really looked at them. And then they start to look at them and they go, well, why are we billing it that way? Why is our EMR system set up this way? They start to ask questions, and then they have to kind of educate themselves. And eventually they kind of figure out like, oh, we're actually doing this wrong, right? It's usually takes the doctor a while to get to that point of
Right.
making that realization, that maybe calling somebody like me and saying, hey, is this okay? So yeah, doctors for the most part, go into private practice kind of blind to these issues without really understanding them that well. I don't really know what the solution to that is. It's not like we want doctors spending tons and tons of time worrying about billing. But I would say, like any business, you have to have you have to devote a certain amount of your time to managing the people that are doing the other functions. And even though that's not the fun part of being a doctor, it's not how you want to spend your time. If you're going to be a private practice doctor and you're going to make your money that way, you are kind of responsible for it, and you have to spend at least a little bit of time being responsible.
Yeah. And the only other thing I would add to that, to the flip side, is that while some of these doctors may be concerned that they're overbilling, I would say from the doctor's perspective and from a financial incentive perspective, what's probably more often than not happening is you're actually underbilling. Like
Right.
you're probably not coding correctly because you're undercoding and you didn't add those diagnosis codes to the patient's chart. Like we're looking at charts sometimes and we're like, doctor, there's literally no problems in this patient's health chart, but then their medications indicate that they've got like diabetes and hypertension and like a whole bunch going on. So which one is it? And if if the matching the diagnosis codes are not in their chart, then your patient population actually looks a lot healthier than it actually is, right? So,
Right.
I would say it's even worth just from a strictly financial perspective. And again, this kind of goes back to the ACO conversation. You might want to get involved in one of those because they do a lot of that oversight for you, and they've got data aggregators and they're able to run them and say, this is kind of red flagging. You're overbilling, you're underbilling, you're doing something. Yeah, really interesting. I think finally we'll finish out this conversation. I appreciate you spending so much time. In our space specifically with like chronic care management, remote patient monitoring, these preventive care services, again, it's one of these areas where there are people that there are bad players in the market, unfortunately, and I think it gives like a generally bad name. I've taken on clients from people that I've taken on clients that are coming to me from another company or number of other companies, for example, where the care management is outside of the country, which is super illegal. For those of you that don't know, Medicare says that any non-emergency care that is being provided and reimbursed by Medicare has to come from within the United States. So if there's, if you're doing chronic care management and the patients are getting called by people with very, very heavy accents and strange numbers, look into that. But yeah, unfortunately, there's a lot of bad players, and I think that it's something that, and almost rightfully so, that the government is kind of cracking down on, like this specific area. What are maybe, I guess, and we obviously tell our clients, like, look, you're going to know if your partner is not, if you're paying attention, you're going to know very quickly if your chronic care management vendor is not doing a good job. If you're not seeing notes on the patients, if you're not seeing documentation every single month, if you're not seeing like just the basic coordination, which is the actual program is care coordination, if you're not seeing that, then huge red flag. But how can any advice to companies like mine that are trying to, really do a good job. And I know there's definitely a couple others out there that I keep in touch with. There's definitely some good players as well. Any advice to companies like ours in the space that there are people taking advantage? How do we make sure that we are not, we in a sense need to be on a clear path even more than other people because we're possibly in a space that's being kind of looked at?
Yeah, absolutely. And I know this is an area that HHS and DOJ are laser focused on right now, because there was this huge, as huge explosion in telemedicine that happened with COVID. And I think what you're talking about, well, I haven't really thought about it. It's really interesting, this sort of remote monitoring stuff. I would imagine has similar problems to the telemedicine. And I think it goes to what I think of as really the fundamental baseline requirement of Medicare and Medicaid, which is that those systems will only pay for medically necessary services. And the real concern with the telemedicine explosion was that, as access, if you can access a doctor just over a laptop, and if the doctor isn't actually examining the patient, but is then prescribing or recommending, whatever, is there a breakdown? Does that system cause a breakdown in the medical necessity requirement? In other words, are things being prescribed that the patients don't really need? Does the doctor have enough information to actually justify the prescription or the recommendation or whatever it is that's happening, over that telemedicine visit? And and I think honestly, there was also this concern that the telemedicine business was kind of, how do I put this politely? It was sort of like vacuuming up the least qualified providers and providing this very lucrative platform for them. And so instead of being treated by the best doctors, all of a sudden patients were being treated by maybe the, not so good doctors. And that these things combined were kind of leading, again, they look at it leading statistically to big upticks in certain types of prescriptions that they would not have otherwise expected to see. And you put all that together and you can see why, from a policy perspective, you might look at that system and go, gee, that's something we really need to focus on and make sure that what's happening in that system is okay. So this is an area where the government is very, very focused on. I mean, they think of it in terms of telemedicine, but I suspect what you're talking about in terms of remote monitoring might have some of those same issues. Yeah. And again, that at the end of the day, the root requirement is medical necessity, tied with documentation. You also have to document the medical necessity. But that should really be the test to everything you're doing. Is the patient actually getting what the patient needs medically? And as long as they are, and as long as you're documenting that sufficiently, I think you're okay.
Yeah. I couldn't agree with you more. I think that it's a very interesting point that you're mentioning, which is that there's a downside to greater access almost, because as much as we're saying this is amazing because it gives all this better access to patients and demographics that are underserved and this and the other, but you're saying there's also a downside to that, which is that it also gives greater access to maybe bad players to access you. As much access as it gives the patient to the doctor, it gives equal access doctor to patient, and that kind of widens the pool, which is fascinating.
Yeah, again, it's as I've said 3 times already, it's a good system for people who are honest and are well-intentioned, but there will always be people that will try to take advantage of it. Right. And the concern on the government side is this is a system that allows that pretty readily.
Yeah. And yeah, to your guiding, light in this instance, I absolutely agree with you. And it's something that I tell both clients and other vendors all the time. Like, you have to, like, when doctors come to me and they're like, oh, should we be doing this program? And I say, you need to keep the patient at front and center, and specifically with chronic care management, because it's meant to be kind of a holistic care plan and path for patients with specific diagnoses. It's, do you have a medical interest, and do you provide clinical value to the patient for the specific diagnosis code that you are billing under? So if you're a pain doc and you're billing under, I don't know, diabetes, why? Or, why? So again, when ladies and gentlemen, when Jonathan Tycko comes knocking on your door and says, why did Medicare pay you all this money? Have yourself a good answer. Make sure that you feel good about yourself going to sleep at night, that you are actually, and I feel fantastic going to sleep at night, thank God, and so do all our care coordinators, because we see the help that we're able to provide patients every single day, and keeping patients out of the hospital and reducing their utilization, and et cetera, which is the point of the program. So if you can sleep like I sleep at night, you're doing good. If you are questioning whether you are valuable to the patient, maybe hold off on it.
Yeah, can I just say, I'll just make one closing remark that follows up on that, which is that, like I said, 99% of the people in the healthcare business are in it for the right reason and are trying to do the right thing. And then like anything, it's always the bad people that spoil it for the rest of you, right? It's sort of like, and this is why I think the whistleblowers that we represent play such a crucial role in the system, because if you're an honest provider and you're trying to do the right thing, you want to compete against other honest providers. You don't want to compete against somebody who's cutting corners and committing fraud, because that's unfair competition to you. But you also just want to wring those people out of the system, because if there's too many of them in the system, then from the government's perspective, their sort of bureaucratic response is, well, we got to shut the whole thing down. Yeah. And so good ideas sometimes get ruined by bad players taking advantage of them. And so and I say this kind of in defense of whistleblowers, because sometimes whistleblowers get a bad rap. And a lot of times our clients are very worried about sort of being blackballed by other people in the business, or being looked down upon by other doctors for having blown the whistle. It's just this kind of like, sort of tribal instinct. Yeah, right. And what I would say to that is, no. You want these people doing this because you want to wring the bad players out of the system to protect the system so that you can practice medicine the way you want to practice it.
Fabulous. Ladies and gentlemen, Jonathan Tycko, if you are, if someone is a whistleblower interested in getting in touch with you, where and how do they do that?
Well, I'm pretty easy to find if you Google me. I mean, our law firm is Tycko and Zavareei. We also have a whole website that's devoted to our whistleblower practice, and that website is fraudfighters.net, .net for some reason, fraudfighters.net. But there's a lot of information about a lot of the stuff we've talked about on that website, and you can find us there as well.
Fabulous. Jonathan, thanks so much for spending time. Absolutely fascinating conversation. I hope to not see a $17,000 bill in the mail.
No, absolutely not. I do this for fun. I love talking about what I do, and happy to help out.
Really appreciate it.